All right, everybody. It looks like we are live. Let's do the thing. Do the thing, do the thing, do the thing, do the thing.
Two, three, four.
All right. So let's go ahead and get things going here. All right. So mixed topics tonight. So we don't know what area of law it's going to come from. That's where we're at. So we'll begin. So a college student was asleep in his bed in a college dormitory when his roommate, in a drunken fury, entered the room intending to attack the student with an ice pick while he slept. Fortunately, the phone rang and awakened the student. The roommate retreated quickly and threw the ice pick under his own bed in the same room. The next day, the student heard from friends about the roommate's murderous plans and later found the ice pick under the roommate's bed. Even though the college expelled his roommate, the student remains extremely upset and afraid to sleep. In a suit against the roommate for assault, will the student prevail? No, because the roommate did not touch the student. No, because the student was not awake when the roommate entered his room and was unaware until later the roommate was intending to attack him. Yes, because it was reasonable for the student to feel afraid of sleeping in his room afterwards. Yes, because the roommate intended to inflict serious harm. It's going to be B. Because assault depends upon you being in fear of harm. No. All right. Didn't tell me the answer. That's fine. We'll go. Okay. So a homeowner was using a 6-foot step ladder to clean the furnace in his home. The homeowner broke his arm when he slipped. So that's a criminal charge, baby, not a civil charge. This is a civil claim for assault in the previous question. The homeowner broke his arm when he slipped and fell from the ladder. The furnace had no warnings or instructions on how it is to be cleaned. In a suit by the homemaker against the manufacturer of the furnace for recover for his injury, is the homeowner likely to prevail? No, because the danger of falling from a ladder is obvious. No, because the homeowner should have hired a professional to clean the furnace. Yes, because the furnace did not have a ladder attached to it for cleaning purposes. Yes, because the lack of warnings or instructions for how to clean the furnace made the furnace defective. I don't know. I don't want to say C or D though, because like he used a 6-foot stepladder to clean the furnace, but he's suing the furnace manufacturer, not the ladder manufacturer. We'll go with the A. Before putting her home up for sale, a homeowner painted the living room ceiling to conceal major water damage caused by a leaking roof that had not yet been repaired. On the first day the home was offered for sale, the homeowner gave a buyer a personal tour. The homeowner made no statements at all regarding the water damage or the roof. Without discovering the water damage or the leaking roof and without consulting a lawyer, the buyer immediately agreed in writing to buy the home for $200,000. Before the closing date, the buyer discovered the water damage and the leaking roof. The cost of repair was estimated at $22,000. The buyer refused to go through with the purchase. If the homeowner sues the buyer for breach of contract, is the homeowner likely to prevail? No, because no contract was formed since the buyer did not have a real opportunity to understand the essential terms of the contract. No, because the homeowner concealed evidence of water damage and a leaking roof. Yes, because the homeowner made no affirmative statements of fact about the water damage or the leaking roof. Yes, because the buyer acted unreasonably in failing to employ an inspector or conduct an independent inspection of the home. And I think it's B. Because if you have a contract and you have fraudulent representations in it, it's going to be a contract that's void ab initio because it's inducement to the contract makes it unconscionable because you're concealing shit. I think. All right. A landlord and a tenant orally agreed to a commercial tenancy for a term of 6 months beginning on July 1st. Rent was to be paid by the first day of each month, and the tenant paid the first month's rent at the time of the agreement. When the tenant arrived at the leased premises on July 1st, the tenants learned that the previous tenant had not vacated the premises at the end of her lease term on May 31st and did not intend to vacate. The tenant then successfully sued the previous tenant for possession. The tenant did not inform the landlord of the eviction action until after the tenant received possession. The tenant then sued the landlord, claiming damages for that portion of the lease period during which the tenant was not in possession. If the court finds the landlord, what's most like, okay, so by suing the previous tenant for possession, the tenant acted a remedy in lieu of suit against the landlord. The landlord delivered the legal right of possession to the tenant. The tenant failed to timely vacate as required to sue for constructive eviction. The tenant had not notified the landlord before bringing the eviction action. Well, so I mean, the question is, it would be helpful if it told us if this jurisdiction used the American rule or the English rule as far as the possession goes, right? So if the landlord wins, why will it be? It might be A, it might be B. C and D don't make sense. I mean, it could be D or A or B. This one's tough. I'm going to go with this one and say that it's the English rule or the American rule, maybe. I'm not sure. That's the cleanest answer. It could be wrong, though. A plaintiff sued a defendant in federal court for injuries arising out of an accident involving the parties. The plaintiff alleged and presented evidence in trial demonstrating that her injuries had left her legs permanently paralyzed. The jury found in favor of the plaintiff and awarded $5 million in damages. 2 months after the court entered judgment, the defendant was given a videotape made that day showing the plaintiff jogging with her doctor. What is the best way for the defendant to seek relief from the judgment? Move for a new trial, or in the alternative, a remitted to reduce the award in light of shortened duration of plaintiff's injuries. Move for relief from the judgment on the ground the judgment was based on jury's mistaken belief that plaintiff's injuries would be permanent. Move for relief from the judgment on the ground the plaintiff committed fraud in obtaining damage for permanent injuries. Move for relief from the judgment on the ground there was newly discovered evidence that because plaintiff's injuries were not permanent. I'm going to go with D, I think. It's too late to do a remitted. That's going to be a clear error appeal issue. It's a separate claim. Let's go with D. You think C? You think fraud? Why do you think fraud? Because it wasn't a settlement. This was a jury trial. So you're going to ask for relief from the judgment that there's newly discovered evidence that plaintiff's injuries were not permanent. Because that's going to be right answer, I think. Congress enacted a statute prohibiting discrimination in the rental of residential property anywhere in the U.S. on the basis of sexual orientation or preference by any person or entity, public or private. Which of the following provisions provide the strongest basis for Congress' authority to enact the statute? Commerce Clause, Section 8. Oh, you guessed that one? Okay. Well, I feel better then. The defendant is being tried for the murder of a woman who disappeared 10 years ago and confirmed since. Her body has never been found. The prosecutor has presented strong circumstantial evidence she was murdered by the defendant. To help establish the fact of her death, the prosecutor has requested that a judge give the following instruction based on a recognized presumption in the jurisdiction. Quote, A person missing and not heard from in the last 7 years shall be presumed to be deceased. Is the instruction proper? No, because the fact that someone has been not been heard from in 7 years does not necessarily lead to a conclusion the person is dead. No, because the mandatory presumption are not allowed against criminal defendant on an element of the charged crime. Yes, because it's expressed as a rational conclusion that the jury could be required to accept. Yes, because the defendant has a chance to rebut the presumption by offering evidence the woman is alive or has been heard from in the last 7 years. I think D. I read them. Oh, you didn't hear me read them? Yeah, I think B or D too. Oh, D. An executive of an accounting firm was fired and told to immediately leave the building where she worked. The executive went home, but she returned that night to retrieve personal items from her office. When she discovered that her key no longer opened the door to the building, she forced the door open and went into her former office. To avoid attracting attention, she did not turn on any lights in the dark. She knew that she was taking some items that were not hers. She planned to sort these out later and return them. Upon arriving home, she found that she had taken a record book and some financial papers that belonged to the firm. After thinking it over and becoming angry over being fired, she burned the book and the papers in her fireplace. The jurisdiction has expanded the crime of burglary to include all buildings. What crime has the executive committed? Say burglary, but not larceny. Burglary is doing a larceny at night. So basically, so burglary is doing larceny at night in a home or in either a residential home or a building attached to the residential home or part of the curtilage of the residential home, right? So, but this jurisdiction's expanded burglary to include all buildings. So burglary is taking shit from a house at night. So that's not yours. So the stuff, she took stuff that wasn't hers. She burned it too. So she can also be charged with destroying evidence. But yeah, so B, burglary but not larceny in this jurisdiction. A defendant was charged with the crime of defrauding a federal agency where he worked as an accountant. At trial, the court allowed the defendant to call his supervisor at the large corporation where he previously worked, who testified about the defendant's good reputation in the community for honesty. Over objection, the defendant sought to elicit testimony from his former supervisor that on several occasions the corporation had, without incident, entrusted him with large sums of money. Should the testimony be admitted? No, because the testimony is extrinsic evidence on a collateral matter. That's a good answer. No, because good character cannot be proved by specific instances of conduct unless character is an essential element of the charge or defense. Yes, because the evidence is a pertinent character trait offered by the accused. Yes, because it's relevant to whether the defendant was likely to have taken money as charged in this case. Okay, so that's proper character evidence. Okay, C gets the law wrong. No, because that's propensity evidence. So I think the testimony is extrinsic evidence on a collateral matter. You think D? Well, that's what's called, okay, D there, it's relevant to whether the defendant was likely to have taken money as charged in this case, right? That's what's called propensity evidence. It's trying to say that because in some past thing a guy did good or bad, right, that in this instance it's actually charged in this case, he's more or less likely to have done that, right? It's called propensity evidence. It's not allowed as evidence in. Because it's unfair to the jury to be like, oh yeah, so let's say like you got charged for like robbery like 12 years ago, right? And now you're charged with robbery. Like they can't bring up the fact you got charged with robbery 12 years ago because it would make it like, oh, this guy's the kind of guy who robs people, right? And the charge isn't for robbery 12 years ago that was already adjudicated, right? The charge is for this crime in this case only. It's not for past action. So, I mean, it might very well be relevant, but it's propensity evidence. You can't say because somebody acted in this way, in this way, in this way in the past, they're more likely to have acted this way this time. That's not how it works. And also, it's not a character trait. So I think it's got to be no, because the testimony is part of a collateral matter. A wholesaler contracted in a signed writing to sell the bakery 10,000 pounds of flour each week for 10 weeks. The flour delivered to the bakery on Mondays and payment made on Wednesdays of each week. The bakery did all of its weekly bread baking on Tuesdays. On Monday morning of the first week, the wholesaler tendered delivery of 8,000 pounds of flour to the bakery, and the bakery accepted it on the wholesaler's assurance the remaining 2,000 pounds to be delivered later in that evening, which it was. The bakery paid for both deliveries on Wednesday. On Monday the second week, the wholesaler tendered delivery of 5,000 pounds of flour to the bakery and said the remaining 5,000 pounds could not be delivered on Monday but would be delivered by Wednesday. The bakery rejected the tender. Will the bakery legally justify rejecting the tender of the 5,000 pounds of flour? Yes, because the bakery was legally entitled to reject any tender that could not perform perfectly the contract. Yes, because its tender was a substantial impairment of the installment and could not be cured. No, because the tender given was not substantial impairment of the entire contract and the wholesaler had given assurance of a cure. No, because by accepting 8,000 pounds on Monday for the first week, the bakery had waived the condition of perfect tender and had not reinstated it. Okay. Okay, so the whole thing I think is that it would be delivered by Wednesday, right? But the bread does company has all its bakings on Tuesday. So the tender was a substantial impairment of the installment and it could not be cured, I think is the right answer. Because, well, the first time, right, they got the other 2,000 pounds delivered by Monday evening, right? This time they said it would be delivered by Wednesday, right? But the bakery does all its bread baking on Tuesdays, right? And so it would be a substantial impairment and it could not be cured because they would be 5,000 pounds short of flour of the day they actually bake their bread. So I think it's going to be a B. Well, no, they're not legally that conform perfectly to the contract. No, because they already did accept it before, right? They accepted that by Monday night they got the last 2,000 pounds. All right, a man owned land. Well, good for him. He took out a loan that was secured by a mortgage on that land. The man had personal liability on that loan. The man sold the land to a purchaser who expressly assumed the mortgage debt. The purchaser failed to make 2 installment payments. To prevent default and foreclosure, the man paid the overdue installments. After making the payments, the man sued the purchaser for reimbursement. Will the man be likely to prevail? No, because the man did not initiate foreclosure proceedings before seeking reimbursement. No, because the man was personally liable on the loan. Yes, because the law of suretyship permits the man to seek reimbursement. Yes, because the man's transfer of land discharged him from any personal liability on the loan. The man was not personally liable on the loan, and he can't initiate foreclosure proceedings because he doesn't own the land. I don't understand. I think it's D. Well, it's not A or B because the man can't initiate foreclosure. I mean, if the man had still, okay, look, let's go back and see, okay? The man owns the land, right? He takes out a loan by a mortgage on the land, right? And the man who owns the land has personal liability on that loan. Then the man sold the land to a purchaser, and that purchaser expressly, by written contract, right, assumed the mortgage debt. So now the man who owns the land doesn't own the land anymore, and the loan on the land has been assumed. The liability for that loan has been assumed by the purchaser, right? So the purchaser owns the land, and the purchaser owns the mortgage debt, right? A purchaser doesn't pay the mortgage, so the owner of the land doesn't own anything. The land is interest in land is gone. It's not his, right? The purchaser makes 2 installment payment, failed to make them to prevent default and foreclosure by the people who own the loan, not by the man. The man paid the overdue installments. Not sure why he did that. Maybe he just wants to see the bank not take his land. I don't know. After making the payments, the man sues the purchaser for reimbursement. Will the man be likely to prevail? No, because he did not initiate foreclosure proceedings. Well, he could not have sought foreclosure proceedings because he doesn't have an interest in the land or in the mortgage. No, because the man was personally liable on the loan. He wasn't. The purchaser assumed full liability for the loan. So A and B can't be right because they get the facts wrong. Yes, because the law of suretyship permits the man to seek reimbursement. Now, I'm not 100% sure what the fuck the law of suretyship is. I don't even know if it's a thing. So maybe I'm just ignorant about that. So let's do a little bit of quick research. Huh. Okay. Okay. I mean, so okay. So suretyship, right, is basically if somebody is going to have, you can step in to pay a third party can step in, right, to pay the debts of somebody else, okay, right, and so because of that, he could be, and then he's also then able to seek reimbursement, right. So, but the thing is, like, suretyship is a contractual thing. Like, he has to contract. Like, he doesn't automatically get to step in and start paying stuff without a suretyship contract. And so I don't think there's a suretyship contract that's entailed in this. He's acting as if there's a suretyship, but he's not doing it. So I think yes, because the man's transferred land, discharged him from liability on the loan. And he'd be accepting. See, if he took a suretyship, he would be putting himself back in more liable state for the loan. So that could be wrong, but I'm going to go with D. All right, several defendants, senior executives of a corporation, were charged with securities fraud. There you go. The government called as a witness another executive of the corporation who had not been charged and who had been given immunity from prosecution to authenticate handwritten notes that she had made after meetings of the corporation's management team at which the alleged fraud was discussed. The witness testified that she had prepared the notes in her own initiative to help her remember what had happened at the meetings. After the testimony, the government offered the notes into evidence to establish what had happened at the meetings. Should the witness's notes be admitted? No, because the notes are hearsay, not within any exception. No, because the witness's immunity agreement with the government makes her notes untrustworthy unless substantially more prejudicial and probative. Yes, because they are business records. Yes, because they are past recollections recorded. So the witness had prepared them on her own initiative to help remember what had happened at the meetings. So they are not, definitely not business records. This is kind of true, that they are untrustworthy because she had an immunity agreement with the government. They are past recollections recorded, but I'm pretty sure past recollections recorded are only going to be admissible as an exception to the hearsay rule to help refresh memory. I believe. Right. So they can be used for memory, I know, right? But so what are they trying to do with it? So they can use it for refresher testimony for sure, right? Government wants to offer the notes and evidence to establish. Okay, so no, they're being offered. Okay, so no, they're being offered for the truth of the matter asserted here. So no, they can't do that. Nope. So they're hearsay. In this case, they are hearsay without exception. There is an exception to let them be read aloud to refresh her recollection. So, because they are contemporaneous notes, they're notes that happened at the same time as the meeting, right? So they're contemporaneous recorded notes and past recollections, right? And so she can use them to refresh her evidence to refresh her memory on the stand as to what happened at the meeting. But now the government wants to offer the notes actually into evidence to establish what happened. So establish what happened means they're offering them for proof of the truth of the matter asserted in the notes. So under that, they're not business records because they're not normally kept. She did them on her own initiative. They are past recollections recorded, but that doesn't get you into evidence. That gets them to refresh your testimony in the stand. So no, they are hearsay without exception in this case. I'm confident about that. Okay, a state law made it a criminal offense for any state employee to knowingly provide educational services or extend welfare benefits to a foreign national who was in the United States in violation of U.S. immigration laws. The principal of a public elementary school was prosecuted under the law for enrolling and providing education to several foreign nationals he knew to be in the country illegally. All of these actions took place before the new law was adopted, for no federal statute applied to the principal's actions. What constitutional provision would be most helpful to the principal's defense? Due process clause of the 14th Amendment, equal protections clause of the 14th Amendment, ex post facto clause, Article 1, Section 10, privileges and immunities of the 14th Amendment, probably the ex post facto clause. So no Congress will establish no ex post facto laws, which are laws that take effect on actions taken before the law was passed. So I'm going to say ex post facto clause, pretty high certainty of that. Before the close of the evidence in a federal negligence trial, the defendant submitted a proposed jury instruction on contributory negligence. Before instructing the jury, the judge informed the parties of the instructions she would give, but did not include the defendant's proposed contributory negligence instruction, which did not, but did include the court's own instruction on contributory negligence. Neither party objected either then or after the judge had given the instruction. The jury returned a verdict for the plaintiff, and the judge entered a judgment on the verdict. The defense would like to appeal the verdict on the ground the judge should have instructed the jury using the defendant's proposed instruction on contributory negligence. Has the defendant preserved the issue for appeal? No, because the defense failed to object after the judge gave the instructions to the jury. No, because the defendant failed to object after the judge informed the parties of the instructions she would give. Yes, because the defendant submitted a proposed instruction on contributory negligence. Yes, because the judge's failure to give the instruction on contributory negligence amounted to ruling on the instruction. No. So that's really between A and B. So to preserve an issue for appeal, you have to object and get a ruling on that objection, so it's on the record and the judge's reason for the ruling. So it's really, even if they did A, right? Even if the defendant or the plaintiff or no, defendant objected after the judge gave the instructions to the jury, right? That still wouldn't be enough to preserve it, because the judge decided to give an instruction to the jury that was not the instruction that the plaintiff had requested. So after the judge informed the parties that they would give that instruction was the proper and only time to object in order to preserve that for the record. And actually, to preserve it for the record, it would probably require they object after the judge says, here's the instruction I'm giving, and then object again after the judge reads that instruction to the jury. So it's not preserved for appeal because it's more B than it is A. All right. A woman and her sister took a trip to the Caribbean, where they passed through U.S. Customs inspection upon their return. The customs officials found packages of cocaine stitched inside separate carry-on bags belonging to each of them. They were arrested. Upon separate questioning by customs officers, the one broke down and cried, "I told my sister there are too many officers in this airport." The sister didn't give a statement. The woman and her sister were indicted for conspiracy to import cocaine. They were tried separately. At the woman's trial, after the government introduced the above evidence and rested its case, her lawyers moved for judgment of acquittal on the grounds of insufficient evidence. Should the court grant the motion? No, because the evidence shows that both woman and her sister agreed to import cocaine. No, because the evidence shows that both woman and her sister possessed cocaine. Yes, because the evidence shows that only one woman and her sister committed separate crimes of cocaine possession. Yes, because the evidence shows the woman effectively withdrew from the conspiracy when she cooperated by giving a statement. So those not right. No, the court's going to deny the motion. Okay, so the evidence does show they both possess cocaine, but they're being tried for conspiracy in this, right? So separate carry-on bags belong to each of them. So they both definitely have possession of cocaine. And upon questioning, right, one sister said, "I told my sister there are too many officers at the airport." The sister didn't give a statement. So you can use evidence, right, for conspiracy, the statements of a co-conspirator that were given. That's admissible evidence. So it tried separately. The woman's trial, the government introduced evidence about and rested its case. Used above evidence and rested its case. Judgment of acquittal. So I don't know what the acquittal is. Like acquittal on the cocaine possession, on the conspiracy for cocaine, like. I mean, the thing, okay, yes, the evidence shows that. Okay, so this is the woman's trial, not the sister. Okay, so. Wait. Okay. The woman who's on the trial right now, right? She's the one who told them, "I told my sister there are too many officers at the airport." So this isn't the sister's trial. This is the woman's trial. Okay, so the conspiracy thing is going to, okay. They were indicted for conspiracy to import cocaine. They were tried separately. So this is the woman's trial. The woman who told them, "I told my sister there are too many officers at the airport." Introduced evidence and rested its case. The lawyer moved for judgment for acquittal on insufficient evidence. Should the court grant the motion? No, because they both agreed to import cocaine. No, because the evidence shows both women possessed cocaine. I'm going to go with no, because the evidence shows both the woman and her sister possessed cocaine. Yes, because the evidence shows only the woman and her sister. And the sister being Oh, this is a badly written question, I think. The sister freaking is the sister's trial, maybe she can get out of the conspiracy thing. This woman probably can't because she confessed. But saying that she told the sister to do that, right? And they both possess cocaine. It doesn't show that they agreed to import cocaine, but they did. But the evidence doesn't show that. Damn. I'm going to go with that one. We'll move on. A gas company built a large refining facility that conformed to the zoning requirements on land near landowner's property. The landowner had his own home and a mini golf business on the property. In a nuisance action against the gas company, the landowner established the refinery emitted fumes that made many people feel quite sick when they were outside on his property for longer than a few minutes. The landowner's mini golf business had greatly declined as a consequence, and the value of the property had gone down markedly. Is the landowner likely to prevail in the nuisance action? No, because the landowner has offered no evidence demonstrating the gas company was negligent. No, because the refinery conforms to the zoning requirements. Yes, because the refinery substantially and unreasonably interfered with the landowner's use and enjoyment of his property. Yes, because the landowner's value of his property declined. I'm going to go with C. It's a nuisance action, so yes, it's nuisance action for a commercial property, or is more or less a breach of the covenant of quiet enjoyment in a residential property. So we're going to go with that. A plaintiff filed a tort action in a state court and then failed to prosecute the action. Okay. The defendant moved to dismiss the action, and the court granted the motion in an order that stated the defendant's motion to dismiss is granted, and the action is dismissed with prejudice. The court accordingly entered a judgment for the defendant. The plaintiff then filed the same claim against the defendant in federal court, invoking diversity jurisdiction. The defendant has asserted the defense of res judicata claim preclusion in its answer. Yes, it should definitely give state. Should the federal court give preclusive effect to the lower court state judgment? Yes, it should, but we'll see why. No, because it was entered by a state, not federal court. Nope. No, because the state court did not rule on the merits of the dismissal. Doesn't matter. Yes, because the dismissal with prejudice operates as a judgment on the merits. Yes, because the judgment for failure to prosecute operates as a judgment on the merits under federal rules of civil procedure. Why are you being stupid? Well, it was not a judgment for failure to prosecute. It was a motion to dismiss. So C's trying to get too cute. I mean, D's trying to get too cute. A fire that started in the defendant's warehouse spread to the plaintiff's adjacent warehouse. That sucks. The defendant did not intentionally start the fire, and the plaintiff can produce no evidence as to how the fire started. However, the defendant had failed to install a sprinkler system, which was required by a criminal statute. The plaintiff can produce evidence that had the sprinkler system been installed, it could have extinguished the fire before it spread. In an action by the plaintiff against the defendant to recover for the fire damage, is it possible for the plaintiff to prevail? No, because the statute provides only criminal penalties. No, because there's no evidence the defendant negligently caused the fire to start. Yes, because a landowner is strictly liable for harm to others caused by the spread of fire from his premises under the doctrine of Reynolds v. Fletcher. Yes, because the plaintiff was harmed as a result of the defense violation of a statute that was meant to protect against this type of occurrence. Well, the real question here is, what the fuck is Reynolds v. Fletcher? So, or Rylands. So, Rylands v. Fletcher is a case about the flooding of a mine, apparently. All right, so Rylands v. Fletcher doesn't apply here, so it's going to be D. Rylands v. Fletcher is a case where there was apparently somebody had a mine, like a coal mine or some kind of mine that went underneath somebody else's property, and they flooded the mine, and it caused collapse of and damage to the other person's property. And so that was an unforeseen and it was a really odd, it was not a normal use of the land to flood the mine shaft or whatever. And so that says that you can cause the harm to the other people because it was an unusable or unforeseeable use of the land. Rylands v. Fletcher would apply. But no, this is the defendants violated a statute that was meant to protect against this type of occurrence, which is correct. Same thing like there's like a statute that says for all people who are doing performing maintenance on elevators, by a criminal statute, you're required to cordon off, put a rope around the elevator so nobody accidentally goes in and falls. And so a person like doesn't put a rope up and goes in and falls, right? Then they violated a criminal statute, but can also be sued for the negligent act of not putting the rope up and having somebody fall. Yeah. A store owner whose jewelry store had recently been robbed was shown by a police detective a photograph of a defendant who previously had committed other similar crimes. The store owner examined the photograph and then asked the detective whether the police believed the man in picture was the robber. After the detective said, "We're pretty sure," the store owner stated the man in the photograph was the one who had robbed her. The defendant was indicted for robbery. His counsel moved to suppress any trial testimony by the store owner identifying the defendant as the robber. Should the court grant the motion to suppress the store owner's trial testimony identifying the defendant as the robber? No, because suppression of an in-court testimony is not a proper remedy, even though the out-of-court identification was improper. No, because the out-of-court identification was not improper. Yes, because the improper out-of-court identification is necessarily tainted in any in-court identification. Yes, unless the prosecution demonstrates that the in-court identification is reliable. Huh. That's actually kind of tough. Let's not see. That's too strong. Because it's really freaking hard to get freaking identification of a defendant to not go through. I'm gonna go with A. Like, even though it wasn't improper identification, but they're not going to suppress the testimony. A protester entered the IRS office during business hours. Oh shit! He denounced the income tax and set fire to pages from his copy of the IRS code. The fire was extinguished before causing any other damage. The protester was arrested and charged with violating a state law that prohibited igniting a fire in a public building. He claimed his prosecution was unconstitutional under the First Amendment. May the protester constitutionally be convicted? No, because he was exercising his right to freedom of speech by burning a copy of the code. I wish that was the case. No, because a copy of the code belonged to him, and this burning did not infringe upon any legitimate government interest. Yes, because the burning of the code was conduct rather than speech. Yes, because state law is narrowly drawn to further a substantial government interest in prohibiting non-communicative aspects of the act in question. Yes. D. Like, you could light that on. Like, basically what this is saying is that you could light the IRS code on fire out inside of in front of the IRS building, or in the alley, or in your own house. But, excuse me, doing it inside of a public building is dangerous, and it's an act, not an element of speech. Like, you could communicate how upset you are. You could tear it to shreds in the IRS office, but lighting it on fire inside the IRS office, when the state has a law against that, would be a substantial government interest in prohibiting people from lighting shit on fire, which is a non-communicative aspect of the act in question. An engineer entered into a written contract with an owner to serve in the essential position of an on-site supervisor for construction of an office building. The day after signing the contract, the engineer was injured while bicycling and was rendered physically incapable of performing as the on-site supervisor. The engineer offered to sue as an off-site consultant for the same pay as originally agreed by the parties. Is the owner likely to prevail in an action against the engineer for damages resulting from his failure to perform under the contract? No, because the engineer offered a reasonable substitute by offering to serve as an off-site consultant. Well, I don't think that's actually the same. No, because the engineer's physical ability to perform as on-site supervisor was a basic assumption of the contract. Why is that no? Yes, because the engineer breached the contract by disappointing the owner's expectations. Yes, because the engineer's duty to perform was personal and absolute. Jesus. I think two should be yes, and I'd say yes. The engineer's physical ability to perform as on-site supervisor was a basic assumption of the contract. Like it basically assumed that he'd be able to perform on site. But you're not going to be assumed for damages. You can just take the contract out. You can't assume for damages. Oh, okay, it is that. Okay, I meant okay. Basically, okay, yeah. His ability to perform on site, right, was a basic assumption of the contract. You're hiring him for the on site construction thing, right? So assuming he's not able to do that anymore, right, then the contract can't go forward because it basically assumed that. So you can't sue him for damages for something that he can't do. So it is B. I just was thinking about it wrong. All right, 22. A landowner borrowed 100K from a lender and executed a valid mortgage on a commercial tract of land to secure the debt. Okay. The lender promptly recorded the mortgage. Okay. A year later, the landowner conveyed the same tract to a developer by a deed that expressly stated that the conveyance was subject to the mortgage to the lender and that the grantee expressly assumed and agreed to pay the mortgage obligation as part of the consideration for the purchase. The mortgage was properly described in the deed, and the deed was properly executed by the landowner. However, because there was no provision or place in the deed for the developer to sign, he did not do so. The developer promptly recorded the deed. The developer made the monthly mortgage payments of principal and interest for 6 payments and then stopped payments and defaulted on the mortgage. The lender properly instituted a foreclosure proceeding in accordance with the governing law. After the foreclosure sale, there was a $10,000 deficiency due to the lender. Both the landowner and the developer had sufficient assets to pay the deficiency. There was no applicable statute in the jurisdiction other than the statute relating to foreclosure proceedings. At the appropriate stage of the foreclosure action, which party will the court decide is responsible for payment of the deficiency? A developer, because he accepted delivery of the deed from the landowner, and in so doing accepted the terms of the conditions of the deed. The developer, because he is estopped by having made 6 monthly payments to the lender. The landowner, because the developer was not a signatory to the deed. The landowner, because he was the maker of the note and the mortgage, and at most, the developer is liable only as a guarantor on the landowner's obligation. Okay, conveyed the same tract to the developer and a deed that expressly stated the conveyance was subject to the mortgage and to the lender, and that grantee expressly assumed and agreed to pay the mortgage obligation as part of the consideration for the purchase. So this would seem to give, under contract, the grantee the right, or the duty rather, to pay the mortgage. The mortgage was properly described in the deed and was properly executed by the landowner, but there's no provision or place for him to sign the deed, so he didn't. The developer recorded the deed without his signature on it. I think it's going to be the landowner, or the developer rather. I don't know why estoppel would apply because he made 6 payments to the lender. It's not so much that he freaking accepted delivery of the deed, it's that he recorded the deed. So, um, Okay, so also also too to think about, I guess, right? Is that it's not okay. So after so the foreclosure goes through, the foreclosure happens, the mortgage company, the bank, whatever, sells the land, but there's 10,000 that's due to the lender still, and the landowner and developer have evidence. So who's liable for the 10 grand that could not be recovered from? Oh, okay. Well, maybe he didn't assume the mortgage. He assumed the obligation as part of consideration for the purchase, but it's still the landowner's mortgage. I think it's D. All right. A plaintiff sued a defendant alleging that she was seriously injured when the defendant ran a red light and struck her while she was walking in a crosswalk. During the defendant's case, a witness testified that the plaintiff had told him that she was barely touched by the defendant's car. Oh God. On cross-examination, should the court allow the plaintiff to elicit from the witness the fact that he is an adjuster for the defendant's insurance company? All right, so wait. Plaintiff sues defendant, seriously injured when the defendant ran a red light and struck her while she was in a crosswalk. Now, this is the defendant's case. So the defendant is now calling a witness that testifies that the plaintiff, who's a suer here, who's injured, told him she was barely touched by the defendant's car. Now, the plaintiff is going to cross-examine the defendant's witness here. So the court allowed the plaintiff to elicit from the witness the fact that he is an adjuster for the defendant's insurance company. So he works for the defendant. No, because testimony about liability insurance is barred by the rules of evidence. No, because the reference to insurance raises a collateral issue. Yes, for both substantive and impeachment purposes. Yes, but for impeachment purposes only. Well, there's a couple of things here, right? Is that you can't bring up whether or not a person has insurance as part of evidence because if you can say, oh, well, that's okay, they're insured. You can't bring up whether a person does or does not have insurance as part of evidence because that makes the jury way more likely to give you the award because, like, oh, they don't have to pay it anyway. Insurance is going to pay it, so don't worry about that, right? So, but this is not necessarily that the guy has insurance. It's that the witness works for the insurance company, but it would also bring that up. So, okay, so it's hearsay as well, right? It's hearsay as well. So definitely not substantive purposes. I mean, it's not really a collateral issue. So it's either A or D. But it'd be really screwy to be able to put insurance adjuster up there and then not have the freaking jury know that he is an insurance adjuster. That would be kind of prejudicial. I'm gonna go with D just because I don't think the court's gonna let some guy who has an interest in it not be impeached because of that. A private university is owned and operated by a religious organization. The university is accredited by the Department of Education of the state in which it's located. This accreditation certifies the university meets prescribed educational standards. Because it is accredited, the university qualifies for state funding for certain of its operating expenses. Under this funding program, 25% of the university's total operating budget comes from state funds. A professor at the university was a part-time columnist for a local newspaper. In one of her published columns, the professor argued that, quote, religion has become a negative force in society. The university subsequently discharged the professor, giving as its sole reason for its dismissal is her authorship and publication of this column. The university professor sued the university, claiming only that her discharge violated her constitutional right to freedom of speech. The university moved to dismiss the professor's lawsuit on the ground that the U.S. Constitution does not provide the professor with a cause of action in this case. Should the court grant the university's motion to dismiss? So this is going to be a 1983 claim, a U.S. 1983 claim. Be helpful if they told us whether or not it was in state or fucking federal courts. Should the court grant the university's motion to dismiss? Yes, because the First and 14th Amendment protect the right of the university to employ only individuals who share and communicate views. That's not right. Yes, because the action of the university in discharging the professor is not attributable to the state for purposes of the 14th Amendment. No, because the accreditation and partial funding of the university by the state are sufficient to justify the conclusion that the state was an active participant in the discharge of the professor. No, because the U.S. Constitution provides a cause of action against any state-accredited institution that restricts freedom of speech as a condition of employment. Well, well, what really should happen is they should be able to be dismissed. There's a thing called the ministerial exception, which means that if it's a religious university and there's people who work there, whether it's a religious grade school, religious college, religious church organization, whatever, right? Like, they can fire people who don't agree with their religious viewpoints, and it's been held constitutional under what the Supreme Court has called the ministerial exception. But this is not being brought up in this question because I don't know why, but so they're saying it doesn't divide the so it is a cause of action. It's a 1983 claim, so it might be D. Okay, that's not A for sure. I'm gonna say this because it's a private university. Yeah, it's gonna be B. If it was a state school, this could work, but then the state school has qualified immunity, so it's never gonna go forward anyway. But that's still. All right, a plaintiff sued his insurance company for the proceeds of a casualty insurance policy covering his 60-foot yacht, claiming the yacht was destroyed by an accidental fire. The company had denied liability, claiming the plaintiff hired his friend to set the fire. In the hospital the day after the fire, the friend, who'd been badly burned in the fire, said to his wife in the presence of an attending nurse, "I was paid to set the fire." 2 weeks later, the friend died of an infection resulting from his burns. That sucks. At trial, the insurance company calls the wife to testify to the friend's statement. Is the wife's testimony admissible over the plaintiff's objection? No, because marital privilege survives the communicating spouse's death. No, because a statement was made after the conspiracy ended. Yes, because a statement is against interest. Yes, because a statement is by a co-conspirator. Well, if the plaintiff's objection is to marital privilege, well, okay, this question is still okay. So, yeah, marital privilege does survive the communicating spouse's death. It does, because they were married at the point in time when the communication occurred. But is the wife claiming spousal privilege? What is the objection? Is it an objection to hearsay? Is it an objection to marital privilege to exclude the testimony? Oh, joking. Okay, so it's not marital privilege because look, here's why. It was said to his wife in the presence of an attending nurse. So if there's a third party to a conversation, you don't have spousal privilege because you didn't intend it to be private. So that's not, that's very tricky, but no, no, no. Let's see here. Let's see here. All right. I'm going to say it's a statement against interest. Because this is civil property. The co-conspirator thing could play into it if it was a criminal trial, but it's not a criminal trial, it's a civil trial. So, all right. Pedestrian domiciled in state A was crossing a street in state B when he was hit by a car driven by a citizen from a foreign country. Civil procedure question, red alert. Both the pedestrian and the driver suffered injuries. The pedestrian filed a negligence action against the driver in a federal district court in state B, seeking $100,000 in damages. The driver believes the pedestrian was crossing the street illegally and is therefore responsible for the accident. The driver seeks an attorney's advice on how to best respond to the action. Assume that state B is a contributory negligence state. How should the attorney advise the driver to respond? File an answer raising the affirmative defense of contributory negligence and asserting a counterclaim for negligence seeking damages for the driver's injury. Was the driver injured? Oh, both the pedestrian and the driver suffered injuries. Okay. File an answer raising the affirmative defense of contributory negligence and move for judgment on the pleadings. Move to dismiss for lack of personal jurisdiction because the driver is not a citizen of state B. Well, it's diversity jurisdiction, so it doesn't matter. Move to dismiss for lack of subject matter jurisdiction because the driver is not a U.S. citizen. I don't like any of these. So it's not that, because diversity jurisdiction applies to people in different states of the U.S. or also between a person who's a foreign citizen and a citizen of any state. So it's not that. It's not that either. Mm-hmm. Okay, I'm pretty sure on this one now. All right. It's going to be A, file an answer raising. So he's going to respond to the claim, right? Raising the affirmative defense of contributory negligence. And he's going to also counterclaim for negligence, seeking damage for his own injuries. That's what's going to be. Because you can't move to judgment on the pleadings. That's a summary judgment motion. Like, why would you do that? Because it's not going to get you anything. Because contributory negligence is an affirmative defense, but it's not a complete defense. I mean, if you're going to go on the pleadings, then the judge doesn't have enough in front of him to actually rule on the pleadings. That's stupid. All right, 7 years ago, a man, his sister, and his cousin became equal owners and tenants in common of a house. Until a year ago, the man lived in the house alone. The sister and the cousin are longtime residents of another state. 1 year ago, the man moved to an apartment and rented the house to a tenant for 3 years, under a lease that the man and the tenant both signed. The tenant has since paid the rent each month to the man. Recently, the sister and the cousin learned about the rental. They brought an appropriate action against the tenant to have the lease declared void and to have the tenant evicted. The tenant raised all available defenses. What will the court likely decide? The lease is void, the tenant's evicted. The lease is valid, the tenant retains exclusive occupancy rights for the balance of his term. The lease is valid, but the tenant is evicted because 1/3 of the lease term has expired. The man only has a 1/3 interest to transfer. The lease is void, and the tenant is not evicted, but must share possession with sister and cousin. So they're not joint tenants, they're tenants in common. Okay, so the man only does have a 1/3 interest. For 3 years under a lease, the man and tenant both sign. That doesn't make sense. I don't know, man. Because your interest in the property, right, is that hmm, so the man doesn't have a 1/3 interest to transfer. Tenants in common has an undivided interest in the property. So I'm gonna go with that one because he has the right to lease it out for 3-year term, but then the girls have a right to. So they want to evict him. Is the whole thing here, right? The whole thing is that they want to evict the freaking tenant by the lease being declared void, and it's not void. Like the guy has an interest to be there. That's not void. The tenant shouldn't be evicted, but the freaking dude who made the lease is required to pay them 1/3 of the rent for the rest of the lease. But the lease is valid. He can lease his interest in it, but he doesn't have exclusive occupancy rights. So the sister and the cousin also have an occupancy right. This doesn't make any sense at all. Okay, there we go. This one. The lease is valid. The tenant is not evicted by to share possession with the sister or cousin. Yeah, that's correct. That's correct. A man and his friend were watching the televised football game at the man's home. Upset by a penalty called by the referee, the friend threw a bottle of beer at the man's television, breaking the screen. Enraged, the man picked up a nearby hammer and hit the friend in the head with it. The friend died from the blow. Jesus. The crimes below are listed in descending order of seriousness. In a jurisdiction that follows common law principles, what is the most serious crime of which the man could properly be convicted? Murder, voluntary manslaughter, involuntary manslaughter, assault. Well, I mean, it's hot blood, right? So, I mean, it could be murder too, but I mean, I'm not sure. Probably voluntary manslaughter. I'm thinking that's hot passion. Under common law, there's no murder too. There's just murder. So I'm gonna say voluntary manslaughter. In a statutory scheme, it might be murder too. It's murder in the second degree, right? Maybe. All right. Oh God, here we go. A schizophrenic patient who was institutionalized in a psychiatric facility pushed a nurse down a stairwell at the facility. The nurse, a paid employee of the facility who was trained to care for schizophrenic patients, was injured. The patient is an indigent whose care is paid for by the government. This jurisdiction generally follows the rule that a person with a mental deficiency is held to the standard of a reasonable person. In a negligence action brought by the nurse against the patient's lawyer will argue the patient should not be held responsible for the nurse's injury. Which of the following facts will be least helpful to the patient's lawyer's argument? The nurse was a professional caregiver. The nurse was trained to care for patients with schizophrenia. At the time she pushed the nurse, the patient thought she was being attacked by an elephant. The patient is an indigent whose care is paid for by the government. Which of these will be least helpful to the patient's argument in trying to argue that the schizophrenic patient should not be held responsible for shoving the nurse down a flight of stairs? C, I think, because the jurisdiction follows the rule that a person with a mental deficiency is held to the standard of a reasonable person. So the fact that she thought she was being attacked by an elephant, which goes to her mental state and the fact she is suffering from mental disorder, right, in this jurisdiction is not going to matter for the defense. But the fact the nurse is a professional caregiver, she could reasonably expect that. She's been trained to deal with patients with schizophrenia, and it's an indigent who's paid for by the government. It's a patient. That's all more relevant, I think. I'm going to say medium level. All right. An experienced rancher contracted to harvest his neighbor's wheat crop for $1,000 when the crop was ripe. In early September, the neighbor told the rancher that the crop was ripe. The rancher delayed because he had other customers to attend to. The neighbor was concerned that delay might cause the crop to be lost, for hailstorms were common in that part of the country in the fall. In fact, in early October, before the crop was harvested, it was destroyed by a hailstorm. Is the rancher liable for the loss? No, because no time for performance was established in the contract. No, because the neighbor failed to tell the rancher the crop might be destroyed by a hailstorm. No, because at the time the contract was made, the rancher had reason, or yes, because at the time the contract was made, the rancher had reason to foresee the loss as a probable result of his breach. Yes, because a party who undertakes a contractual obligation is liable for all the consequences that flow from his breach. Well, is liable for all consequences that flow from his breach. Well, not all. Well, this can't be right because it contemplated the time as when it was ripe, right? It was ripe, so it should have gone. The rancher's under no obligation to tell him it might be destroyed by a freaking hailstorm. See, this is a bit extreme. So he contracted to harvest it when the crop was ripe. It was ripe. He delayed because he was doing other stuff. So he was taking other interests above this guy's interest. The neighbor was concerned that doesn't really matter. In early October, so he made it a whole month to breach, right? So by the time the contract was made, did he have reason to foresee the loss as a probable result of his breach? I don't know. This is a bit extreme, but I'm not sure if it's A. If I can, I don't know, D. All right. A shop owner domiciled in State A had sued a distributor in a federal district court in State A for a breach of contract. Why would you do that? The shop owner sought 100 grand in damages for allegedly defective goods and that the distributor had provided under the contract. The distributor is incorporated in State B with its principal place of business in State C. Okay. The distributor brought in as a third-party defendant the wholesaler that had provided the goods to the distributor, alleging that the wholesaler had a duty to indemnify the distributor for any damages recovered by the shop owner. The wholesaler is incorporated in State B with its principal place of business in State A. The wholesaler has asserted $60,000 counterclaim against the distributor for payment of the goods at issue, and the distributor has moved to dismiss the counterclaim for lack of subject matter jurisdiction, should the motion be granted. So this is a motion for the counterclaim. All right, so no, because the wholesaler and distributor's principal place of business are diverse. No, because there's supplemental jurisdiction. Oh, somebody posted a comment on Twitch that sounds like a crazy person. Yay for them. No, because there's no diversity of citizenship. Or yes, because there is no diversity of citizenship between the distributor and the wholesaler. Yes, because there's no diversity of citizenship between the shop owner and the wholesaler. Okay, well, okay, the wholesaler is incorporated where, right? We got to see here. Okay, the shop owner is in State A and the wholesaler is in State A. The wholesaler is incorporated in State B and the distributor is in State B. The distributor brings in the wholesaler, asking them to indemnify, okay? So trying to dismiss the counterclaim. So the question is supplemental jurisdiction for a third party. I want to say supplemental jurisdiction does not apply for the counterclaim. And I think too, like the third party counterclaim has to be freaking over 75. The question is, see, See, it's not going to be able to do supplemental jurisdiction with a devised diversity jurisdiction. So let me see. I'm 68% sure. All right. A man decided to give his farm to his nephew. The man took a deed to his attorney and told the attorney to deliver the deed to the nephew upon the man's death. The man also told the attorney to return the deed to him if he asked. But you can die. None of these instructions to the attorney were in writing and the deed was not recorded. The man then emailed the nephew informing him of the arrangement. Shortly thereafter, the nephew died testate. In his will, he devised the farm to his daughter. Several years later, the man died intestate, survived by 2 sons. The nephew's daughter immediately claimed ownership of the farm and demanded the attorney deliver the deed to her. Must the attorney deliver the deed to the daughter? No, because a gratuitous death escrow is void unless supported by a written contract. No, because the man never placed the deed beyond his control. Yes, because the death of the nephew rendered the gratuitous death escrow irrevocable by the man. Yes, because the deed to the nephew was legally delivered when the man took it to his attorney. I'm going to go with the deed was never beyond his control. A plaintiff sued for injuries arising from a car accident, claiming a back injury. At trial, she wishes to testify that before the accident, she had never had any problems with her back. Is the plaintiff's proposed testimony admissible? No, because the plaintiff has not been qualified as an expert. No, because the plaintiff's pain could have been caused by factors arising after the accident, such as an injury at work. Yes, because it's probative of the evidence of the plaintiff's injury. Yes, because the testimony of parties is not subject to the lay opinion rule. Fuck's the lay opinion rule? Lay opinion is people you can test about what's in your own experience. You can't test about. I mean, heard the lay opinion rule. I mean, yes, it's probative of the plaintiff's injury for sure. I'll go with that, but it's a stupid way to frame it. A farmer kept antiques in an uninhabited farmhouse on his property. The farmhouse had been broken into several times in the past, and some of the farmer's goods had been stolen. Instead of posting no trespassing signs, the farmer decided to install an alarm system to deter intruders. While the farmer was in the farmhouse installing the alarm system, he heard a window open in the adjoining room. The farmer crept very quietly to the door of the room, threw open the door, and found an intruder, a young child. The farmer immediately struck the child, a 10-year-old girl, very hard in the face, breaking her nose. In an action on behalf of the child against the farmer to recover for the injury to her nose, is the child likely to prevail? No, because the farmer did not use deadly force. No, because the farmer had probable cause to believe the child was a thief. Yes, because the farmer should have posted a no trespassing sign. Yes, because the farmer used excessive force. This is a fucking battery charge. I don't understand. I'm assuming it's a battery charge. But he did post a no trespassing sign, I thought. Instead of it. So that's a trespass to land thing. This is not. Also, excessive force doesn't. Okay, whatever. That's a stupid question. I'm getting pissed now. A state law that restricted abortion was challenged in a state court as a violation of the Due Process Clause of the 14th Amendment to the U.S. Constitution, and as a violation to a similar due process provision in the state's Constitution. The case has made its way to the state's highest court, which ruled the law violated the due process provisions of both the U.S. and the state constitutions. If petitioned to do so, may the U.S. Supreme Court exercise jurisdiction to review the state court's decision? No, because the state court's decision in the case rests upon adequate independent state law grounds. No, because the U.S. Supreme Court has appellate jurisdiction only over state court decisions that determine the constitutionality of federal laws. Yes, because the U.S. Supreme Court has appellate jurisdiction over any ruling of a state's highest court based upon an interpretation of federal law. Yes, because the Supreme Court has appellate jurisdiction over decisions that find state laws in violation of the federal Constitution. So the challenge in state court is a violation of the 14th Amendment for due process. Okay. So the Supreme Court of the state ruled that it violates due process of the U.S. Constitution and state constitution. Well, it's not independent and adequate state law grounds. I'm going to say that. All right. A defendant was charged with attempted murder. At the preliminary hearing, the presiding judge heard testimony of 4 prosecution witnesses and found that the prosecution had failed to establish probable cause the defendant had committed an offense. Accordingly, dismissed the charge. The prosecutor then called the same 4 witnesses before a grand jury. The grand jury indicted the same defendant for attempted murder. The defendant has moved to quash the indictment on the grounds of double jeopardy. How should the court proceed? Wait, he was charged with attempted murder and indicted him. All right. Grant the motion because the dismissal of the first charge on the merits, whether correct or incorrect, bars any further prosecution. Grant the motion unless the prosecution has evidence that was not presented in the first case. Deny the motion because the defendant has not been in jeopardy of conviction on the attempted murder charge. Deny the motion because the protection of double jeopardy clause does not come into play until there's been a conviction or an acquittal. Well, if there was a jury and panel, double jeopardy attaches. So the question is, it's a preliminary hearing, so trial hadn't started yet. It's probably going to have to deny the motion because it was not in jeopardy of conviction. That's it. Sucks to be him, though. A niece had worked in her aunt's bookstore for many years. The bookstore business, which was housed in a building that the aunt leased, was independently appraised at $200,000. The aunt decided to retire. She wrote to the niece expressing her affection for the niece and offering to sell her the bookstore business for $125,000 if the landlord would agree to transfer the lease. The letter also specified when the aunt would transfer the business. The niece wrote back accepting the aunt's offer. In a phone call to the niece, the aunt stated the landlord had approved the transfer of the lease and that she should now ask her attorney to draft a written contract so there could be a record of the terms. Before the attorney finished drafting the contract, the aunt changed her mind about selling the business and informed the niece of her decision. In an action for breach of contract brought by the niece against her aunt, is the niece likely to prevail? No, because the motivation for the transfer of the business was the aunt's affection for her niece, not the price. No, because the promised consideration was inadequate in light of the market value of the business. Yes, because the condition concerning the landlord's assent to the transfer of the lease was beyond the control of either party. Yes, because the document being drafted by an attorney was merely a record of an agreement already made and not a condition to it. Okay, she wrote and said, I love you, niece, and we're going to sell you the bookstore for $125K if the landlord agrees to transfer the lease. So there's a condition that the landlord would agree. The letter also specified when she would transfer the business. The niece wrote back accepting the offer. The aunt called the niece and said that the landlord had approved the transfer, and she asked her attorney to draft a written contract so it'd be record of the terms. Before the attorney finished drafting it, the aunt changed her mind and informed the niece she changed her mind. Okay. But this doesn't really matter, though, because document rejection was merely a record of an agreement already made, not a condition to it. This is true, but it's enough to cause a breach of the contract. The motivation doesn't matter in the fucking breach of the contract either. And the promised consideration was not inadequate. And the landlord gave consent, so it doesn't matter. I mean, D is the only one that makes sense, but it doesn't make that much sense. That ticks me off. An attorney for a plaintiff in an action filed in a federal district court served the defendant with a summons, the complaint, and 25 interrogatories asking questions about the defendant's contentions in the case. The interrogatories stated that they were to be answered within 30 days of service. Is the defendant likely to proceed in obtaining a protective order? Oh, the defendant is likely to succeed in obtaining a protective order on which of the following grounds? A. Interrogatories are only proper to discover facts, not contentions. Interrogatories may not be served until an answer to the complaint is filed. Interrogatories may not be served until the parties have conferred to arrange for initial disclosures and prepare a discovery plan. The interrogatories exceed the number permitted without permission for the court or an argument or an agreement between the parties. I know 25 is a fine amount of interrogatories to have. That's okay. Well, I mean, interrogatories can discuss, ask whatever you want. So protective order probably is going to be based on the fact that there was no arrangement for initial disclosures, which would be an issue. So it's Rule 33, right? The question is, the question is, I don't understand. The only thing is that there was no discovery that you can file them at any time, right? May be served until after an answer to the complaint is filed. See, I just don't. I just need to review Cipro, I guess. Damn. Okay, well, freaking. Okay, that A is wrong. We know A is wrong. Okay, we know A is wrong. C, might be correct because it's a federal court, district court case, right? You're not going to get a protective. Okay, A's wrong. B, I think, is wrong. D is definitely wrong. 25 is the right amount. Interrogatories may not be served until answer to the complaint is filed. And you can file them whenever. They're just not required. You can't start the time ticking. But initial disclosures usually have to be carried out before discovery is the only thing. So, so it's Rule 26. Okay. See, that's not true. It's not true. I'm going to go with that. B is probably the best answer. It still sucks, but I guess so, because you can answer. Because if your freaking case is okay, so maybe B is right. So if the case is dismissed on a 12B6 motion of failure to state a claim, right? Then you're not ever actually going to get into discovery because the case is going to be dismissed before discovery even happens. So B was right, I think. A businesswoman owned 2 adjoining tracts of land, one that was improved with a commercial rental building and another that was vacant but abutted by a river. 20 years ago, the businesswoman conveyed the vacant tract to a grantee by a warranty deed that the businesswoman signed, but the grantee did not. Well, that's stupid. The deed contained a covenant by the grantee as owner of the vacant tract that neither he nor his heirs or assignees would erect any building on the vacant tract in order to preserve the view of the river from the commercial building on the improved tract. The grantee intended to use the vacant tract as a nature preserve. The grantee promptly and properly recorded the deed. Why would you record a deed that you didn't sign? Anyway, last year, the businesswoman conveyed the improved tract to a businessman. A month later, the grantee died, devising all his property, including the vacant land, to his cousin. 6 weeks ago, the cousin began constructing a building on the vacant tract. The businessman objected and sued to enjoin the construction of the building. Who is likely to prevail? The businessman, because the commercial building was constructed before the cousin began his construction project. The businessman, because this construction is bound by the covenant made by the grantee. The cousin, because the equitable servitude does not survive the death of the promisor. The cousin, because the grantee did not sign the deed. I think equitable servitude does not survive the death of the promisor, but you can that doesn't make sense. I think it was bound by the covenant made by the grantee, because if you well, maybe I'm wrong, we'll see. An actor straight out of drama school and an agent entered into a 1-year written contract that described the services the agent would provide. Because he was eager for work, the actor agreed in the contract to pay the agent 15% of his yearly earnings. At the end of the year, the actor was so pleased at his many roles that he gave the agent 20% of his earnings. After the first contract had expired, the actor and the agent decided to continue working together. They photocopied their own contract, changed the date, and signed it. At the end of the year, a dispute arose as to what percentage of the earnings the actor owed. It is a trade practice in the acting profession for actors to pay their agents 10% of their yearly earnings, payable at the end of the year. What percentage of the actor's earnings is the court most likely to award the agent? Nothing, because the contract is indefinite. 10, because the trade usage is the applicable default rule. 15, because it was an express term of the contract. Or 20%, because the course of dealing is given greater weight than trade usage. It's going to be 15 because it was an express term of the contract. He agreed in the contract 50% of his yearly earnings. At the end of the year, he paid him 20%, so he gave him a bonus, right? After the first contract expired, they decided to continue work together. They photocopied the old contract, changed the date, and signed it. The old contract said 15%. That's trade practice, only give it 10. You're always entitled to give more than what the trade practice is because you really like them. This is not going to happen, though. 15, because it was express terms of the contract. Yeah, B. A man and a woman, both purse snatchers, independently entered a grocery store, each with the intent to steal purses from unsuspecting shoppers. A man approached the victim, grabbed the strap of the purse that was hanging from her shoulder, and pulled. The victim screamed and tried to hold on to the purse, but the man knocked her down, causing her to lose her grip on the purse. The man escaped with the purse. During the commotion that arose when the man's victim screamed, the woman approached the shopping cart of a shopper who had turned toward the noise and wandered away from her cart. The woman reached into the now unattended shopping cart, grabbed the shopper's purse, and quickly walked away, also escaping with the purse. Both purse snatchers were apprehended a short while later. Which of the two purse snatchers properly could be convicted of a robbery? Both the man, but not the woman, because a robbery involves using or threatening physical force. Yeah. A mining company that operated a copper mine in a remote location kept dynamite in a storage facility at the mine. That's lovely. The storage facility was designed and operated in conformity with the state-of-the-art safety standards. In the jurisdiction, the storage of dynamite is deemed an abnormally dangerous activity. Dynamite that was stored in the mining company's storage facility and had been manufactured by an explosive manufacturer exploded for an unknown cause. The explosion injured a state employee who was at the mine performing a safety audit. The employee brought an action in strict liability against the mining company. What would the mining company's best defense be? The mine was a remote location. The mining company did not manufacture dynamite. The state employee assumed the risk of injury inherent in the job. The storage facility conformed to state-of-the-art safety standards. I think it's going to be that because, okay, dynamite is obviously deemed an abnormally dangerous activity. The storage of it is, right? But it operated in conformity with state-of-the-art safety standards, which is the requisite level of care to store a abnormally dangerous item. I don't think assuming the risk of inherently a job is enough to get you over the burden for a strict liability action. The action is not for making the dynamite. The action is for improperly storing it. And because it's a strict liability thing because it's an inherently dangerous substance, but it's got to be D. A recently enacted federal statute requires the president to make each appointment of the U.S. ambassador to a foreign country from a list of 3 individuals. The list is to be compiled by the Senate Foreign Relations Committee and approved by the full Senate in advance of the appointment. The statute also provides that the Senate confirmation of the appointment is deemed to occur automatically 13 days after the time the president names an appointee from the list, unless the full Senate determines otherwise within a 30-day period. The statute constitutional? Hell no, it's not. No, because the statute violates the constitutional requirements for appointment of a principal officer of the U.S. No, because the statute impermissibly restricts the plenary foreign affairs power of the president. Yes, because it's consistent with the constitutional requirement the presidential appointment of ambassadors be with advising Senate and the Senate. Yes, because the statute is a necessary and proper means of furthering Congress' power to regulate commerce with foreign states. So it's not. The question is why is it not constitutional? It violates the constitutional requirements for appointment of a principal officer. No, because it impermissibly restricts plenary foreign affairs power of the president. Well, it's more the appointment, but I'm not sure that freaking ambassadors are principal officers. I know they require invited consent in the Senate, but I'm going to say this. Because it's not the foreign affairs power that's the issue, it's the appointment and consent that's the issue. A plaintiff who has been injured in an automobile collision sued for damages. The defendant denied negligence and denied the plaintiff's injuries were severe. All right. At trial, the plaintiff has offered evidence of a color photograph of himself made from a videotape taken by a television news crew at the scene of the collision. The plaintiff has demonstrated the videotape has since been routinely reused by the television station and the footage of the plaintiff was erased. The photograph shows the plaintiff moments after the collision with his bloodied head protruding at a grotesque angle through the broken windshield of his car. Should the photo be admitted over the defendant's objection? No, because the plaintiff failed to establish a duplicate cannot be found. No, because the plaintiff has failed to produce the original videotape or a duplicate. Yes, because it tends to prove a controverted fact. Yes, because a photograph that establishes a disputed fact cannot be excluded as prejudicial. Well, that's not true. I mean, basically, it's the best evidence rule we're trying to get at. And it's not that a duplicate cannot be found. That doesn't really matter. So I think it will be. It can't. It's got to be. So its relevance is in for that, but so the plaintiff has shown that the original has been destroyed, the footage has been destroyed, and the photograph is taken from that, and so that's the best evidence that's available. It's got to be a 404 or 401 relevance thing. That should be, we should be good. It can be prejudicial if it's not probative, but that's not enough to exclude it. So under state law, a drug company that makes a false factual claim about a prescription drug is strictly liable in a tort to any user of the drug. In an advertisement promoting the sale of a particular drug, a drug company claimed the drug was safe for children. Suit was filed against the company on behalf of a child who allegedly was harmed as a result of taking the drug. At the time the child took the drug, the available medical studies supported the company's claim the drug was safe for children. But later research proved the drug was actually harmful to children. The company has moved to dismiss the suit on First Amendment grounds. Should the court grant the motion? No, because false or misleading commercial speech is not constitutionally protected. No, because the drug business is subject to extensive health and safety regulation. Yes, because liability cannot be imposed for false statements without showing of actual malice. Well, in defamation, that's true. Yes, because the company's claims about the drug were a matter of public concern. Okay, so the answer is no, it should not deny it, or it should not grant it, but why is the question. False or misleading commercial speech is not constitutionally protected. I mean, it tends to be true. But we also have a statute here that says any company that makes a false factual claim about a drug is strictly liable in tort for the users of the drug. So that statute seems to be I'm gonna go with that. A retailer brought a federal diversity action against a wholesaler alleging a breach of contract for fraudulent misrepresentation. After the parties presented their evidence at trial, the court instructed the jury on the law. Okay. Neither party filed a motion for judgment as a matter of law before the case went to the jury. The jury found for the retailer on both claims, and the court entered a judgment on the verdict. The wholesaler moved for a new trial and for judgment as a matter of law, arguing the evidence was insufficient to support the jury verdict on either claim. The court acknowledged there had been problems with some of the evidence, but denied the motions. The wholesaler appealed, challenging the sufficiency of the evidence. What should the appellate court consider, or should the appellate court consider the wholesaler's challenge? No, because the determination of sufficiency of the evidence is solely within the jury's province. No, because the wholesaler did not raise sufficiency of the evidence issue in a motion for judgment as a matter of law before the case went to the jury. Yes, because the challenge was raised and ruled on by the trial court before the wholesaler filed the appeal. Yes, because as the trial court acknowledged, the wholesaler has strong arguments on the challenge. Well, the time for a motion as a judgment as a matter of law would be after the evidence is closed, but before the jury is instructed on the law, or even after the jury is instructed on the law, before it delivers a verdict. They entered a judgment now, moved for a new trial, arguing of insufficient evidence. The court acknowledged there had been problems with some evidence. It denied the motions. It should deny the motions. It already went to I'm gonna say B. They didn't preserve it. A bank agreed to lend the merchant 10 grand for 1 year at 8% interest. The loan proceeds were to be disbursed within 2 weeks. The merchant intended to use the loan proceeds to purchase a specific shipment of carpet for resale at an expected profit of $5K, but said nothing about these plans to the bank. The bank failed to disperse the proceeds and refused to assure the merchant that it would do so. The merchant was able to secure a loan from another lender at 10% interest for 1 year. However, by the time the merchant started the application process for a substitute loan, he was too late to pursue the opportunity to buy the shipment of carpets. In an action against the bank for breach of contract, which of the following amounts is the merchant likely to recover? Nothing, because damages for lost opportunities are not recoverable. Nothing, because the parties failed to tacitly agree that the merchant would be entitled to damages in the event of the breach of the bank. The difference in the cost of loan, the cost over time between a 10% and an 8% loan, and the merchant's foreseeable loss is $5K. The question is, were they a volume seller? Okay, so this is a contract. So we're talking about the ability to cover, so basically cover cost. So it doesn't say anything about there being a volume seller. So the ability to cover for the lost sales is not in there. The most they can cover is the difference in cost between a loan of 8 and 10 for a breach. A rancher and his neighbor were involved in a boundary dispute. In order to resolve their differences, each drove his truck to an open pasture area on his land where the two properties were separated by a fence. The rancher was accompanied by 4 friends, and the neighbor was alone. The neighbor got out of his truck and walked towards the fence. The rancher got out of his truck but simply stood by it. When the neighbor came over the fence, the rancher shot him, inflicting serious injury. Oh, Jesus. In a battery action brought by the neighbor against the rancher testified that he actually thought his neighbor was armed, although he could point to nothing that would have reasonably justified this belief. Is a neighbor likely to prevail? Okay, the rancher had 4 friends there. The neighbor had none. He walked on to, yes, because no, because the rancher was standing his own property, had no obligation to retreat. Yes, because the rancher suspected the neighbor was armed. Yes, because deadly force is never appropriate in a property dispute. Yes, because it was unreasonable for the rancher to consider the use of a gun necessary for self-defense. He's not claiming self-defense. Yes, because the rancher was standing on his own property. So he brought a battery charge, right? And I'm not even sure. All right. So self-defense is defense to a battery charge, but self-defense isn't alleged here. And even if it was, he's lacking the objective reasonability of self-defense. That makes no sense. It's also not. This is stupid. Well, in Texas you can use deadly force to defend property, but Texas is the only place where you can use deadly force to defend your property. I guess I'm gonna go with there's no duty to retreat. Okay, I'm just gonna go C because majority freaking jurisdictions you can't defend property, but property dispute's not the right thing to defend property, not dispute. Like this is stupid. Boundary dispute, open pasture area, two properties separated by a fence, four friends, neighbors alone. Neighbor got out of his truck, rancher got out, rancher shot him, battery against the rancher. He thought he was armed. That's not a fact. It's gonna be C, but that's stupid. A cyclist sued the defendant corporation for injuries sustained when she was hit by a truck owned by the defendant and driven by its employee, who was making deliveries for the defendant. The day after the incident, the employee visited the cyclist in the hospital and said, "I'm sorry for what I did." At trial, the employee has testified that he exercised due care. While the cyclist's testimony relating what the defendant's employee said at the hospital admissible to prove negligence. Why is the cyclist's testimony relating to the defendant's employee said at the hospital admissible? It's a prior inconsistent statement. It's a statement against interest. It's a statement by a party opponent's agents. It's a statement of the existing state of mind. Well, it is an inconsistent statement. I think inconsistent statement though is just to impeach them, not for actually getting in. So a statement against interest would be the fucking right. But the thing about that is that's for a declarant that's not available. So the declarant's available, obviously he's in trial. I'm gonna go with party opponent's agent, but it's a little bit much though. All right, police who had a probable cause to arrest a man for a series of armed robberies obtained a warrant to arrest him. At 6 a.m., they surreptitiously entered his house and, with guns drawn, went to his bedroom, where they awakened him, startled him, and he asked, "What's going on?" The officer replied, "We've got you now." Another officer immediately asked the man if he committed a particular robbery, and the man said he had. The police then informed him that he was under arrest and ordered him to get dressed. Charged with robbery, the man has moved to suppress the use of his statement as evidence. What's the man's best argument for suppressing his motion? They didn't give him his Miranda warnings. The statement was not voluntary. He was not informed he was under arrest until after he made the statement. The police did not have a search warrant authorizing entry to the house. They obtained an arrest warrant. So we've got you now. Asked him if he committed a particular robbery. Yes, he had. Charged with robbery, he moved to suppress the use of his statement as evidence. Okay, this isn't going to be right. That's not going to be right. I mean, yeah, he said it on Miranda, but I don't think that really matters because the statement was voluntary. So he doesn't really have a good freaking. He wasn't informed he was under arrest until after he made the statement. So he wasn't in police custody yet. This would be all reasons to not suppress the statement. He wasn't Mirandized, but it was a voluntary statement, so Miranda wouldn't matter. So he has to argue it was involuntary. I mean, that's got to be that's the only thing he can save his ass at all. All right. A seller owns a 400-acre tract of land with 5,000 feet of frontage on a county highway. The seller and buyer entered into a written agreement for the sale of a portion of the tract identified as a parcel of land containing not less than 100 acres and having not less than 1,000 feet of frontage on the county highway, whose exact location and dimensions are to be determined by parties hereto at the price of $8,000 an acre. Shortly after the execution of the agreement, the parties met to stake out the parcel of land to be sold, but they could not agree. The disagreement intensified and the seller repudiated the contract. The buyer has sued the seller for specific performance. The seller has asserted all available defenses. Is a buyer entitled to specific performance of the contract? No, because a contract for the sale of real property that requires further agreement on an essential element cannot be specifically enforced. No, because the purchase price was not fixed by nor determinable under the contract terms. That's not true. Yes, because the contract bound the parties to act in good faith and agree upon specific land to be conveyed. Yes, because the equity powers of the court enable the court to appoint a master or to take other appropriate action to identify the land to be conveyed. Hmm. Hmm. Right. So specific performance isn't going to be available because there's not fixed terms on everything. So no, because of that. That's gotta be the answer. All right. A woman died devising land she owned in another state to her daughter, who was then 17. A neighbor who owned the property immediately adjacent to the land wrongfully began to possess the land at that time. For 24 of the next 25 years, the neighbor planted and harvested crops on the land, hunted on it, and parked cars on it. However, in the 6th year after he first took possession of the land, the neighbor neither planted crops nor hunted nor parked cars on the land because he spent the entire year living in Europe. The neighbor built a small gardening shed on the land but never built a residence on it. When the daughter was 28, she declared mentally incompetent and had a conservator appointed to oversee her affairs. Since then, she's continuously resided in a care facility. The applicable statute of limitations provides as follows: an ejectment action shall be brought within 21 years after the cause of action accrues, but the person entitled to bring the cause of action is under 18 or mentally incompetent at the time the cause of action occurs. It may be brought by such a person within 10 years after attaining the age of 18 or after the person becomes competent. The daughter's conservator wins an ejection enactment against the neighbor. What will likely be the most likely explanation? The daughter was 17 when the neighbor first took possession of the land. Because the daughter is mentally incompetent, the statute of limitations has been told. The neighbor never built a residence on the land. The neighbor was not in continuous possession of the land for 21 years. So 6th year, he went to Europe. So he wasn't there for so she was 28. So this would be 12 years after. So freaking 10 years after she turned 18, or 6 years after he started doing stuff on the land. It's probably because it's been told. I mean, that's the easiest thing. That's kind of stupid. All right. A plaintiff is domiciled in State A brought a federal diversity action in State A against the defendant domiciled in State B, seeking damages for injuries the defendant allegedly caused the plaintiff in State B. The defendant has never been to State A and has no connections there. The defendant's attorney knows that the defendant was properly served, but does not believe that State A court has personal jurisdiction over her. What is the best way for the attorney to raise the argument that the court lacks personal jurisdiction over the defendant? Move for discovery of the issue of personal jurisdiction? No. Move for a judgment on the pleading seeking dismissal of action for lack of personal jurisdiction? No. Move for sanctions against the plaintiff and attorney for filing action in a court that has no personal jurisdiction? No. Move to dismiss the action for lack of personal jurisdiction based on the complaint allegations and an affidavit from the defendant about her lack of connection to State A. Okay. Defendant that's caused the plaintiff harm State B. Yeah, you got to file in State B. You got to file in the state where the defendant is located. Even if it is a diversity action, it's fine. You still got to do it in the freaking state. So yeah, definitely D. The defendant is on trial for bank robbery. Evidence of the trial has included testimony by a bank teller who was present during the robbery. The teller is testifying for the prosecution after having refreshed her memory by looking at an FBI agent's investigative report that was created shortly after the robbery. The defendant has asked to examine the report. How should the court respond? The court may allow the examination if the report was used by the teller to refresh her memory before testifying, and must allow it if she used it during her testimony. The court must allow the examination, but only to the extent the report contains the teller's own statements to the FBI agent. The court should not allow the examination unless the report was used by the teller to refresh her memory while on the witness stand. The court should not allow the examination because the report was not shown to have been read by and approved by the teller while the matter is fresh in her mind. It's definitely that one. Definitely A. A driver was traveling along a highway during an unusually heavy rainstorm when the roadway began to flood. To protect his car from water damage, his driver pulled his car up a steep, unmarked driveway abutting the highway that led to a homeowner's residence. The driver left his car parked in the driveway and walked home, intending to return when the floodwater subsided. Shortly after the driver started to walk home, the homeowner carefully rolled the car back down his driveway and parked it on the highway shoulder. The floodwater continued to rise and caused the damage to the driver's car. The driver sues the homeowner to recover damage to the car. Is the driver likely to prevail? Yes, because the driver was privileged to park his car on the homeowner's property. That doesn't sound right. Yes, because there were no trespassing signs posted. No, because the driver intentionally drove his car onto the homeowner's property. No, because the homeowner was privileged to remove the car from his property. I mean, the car was trespassing on the owner's property. Trespass is strict liability. He doesn't have to know that you were doing it, but it sounds like he knew he was doing it. It's B or C or D. I'm not sure. See, It's gonna be D, but I'm not positive 100%. All right. A defendant was charged with battery defined as at common law. At a trial, an expert witness testified for the defense that the defendant was an athlete, was under the influence of performance-enhancing drugs at the time he committed the battery, and that he would not have done so had he not been so influenced. The defendant asked for an instruction to that effect that the jury believed that he was influenced by the drug at the time of the crime and would not have committed it otherwise. They had to acquit him. Which of the following circumstances would most aid the defendant's argument in favor of such an instruction? Evidence the defendant was addicted to the drug and has an overwhelming urge to consume it. Evidence the defendant's coach who gave him the drug told him it was only aspirin. Evidence the victim of the assault taunted the defendant about his use of the drug immediately before the assault. Expert testimony that a reasonable person on consuming his drug may experience uncontrollable rages. Well, that's the only thing that goes to battery, that he somehow didn't have the requisite level of intent. It wasn't intentional for him to do that. So that's the only thing that's going to save his ass. A state owned a large natural gas field and took bids for its exploitation. The highest bid came from an interstate pipeline company that distributed natural gas to providers throughout the country. A local gas company submitted the next highest bid, which included the commitment that would pass along local customers any savings it was awarded in the contract. The state awarded the contract to the local company. The interstate company sued to overturn this decision. Should the interstate company prevail? No, because the state has a compelling interest in reducing the cost of gas for state citizens. No, because the state acted as a market participant. Yes, because the state acted irrationally by not choosing the highest bidder and thus denied the interstate company due process of the law. Yes, because the state discriminated against interstate commerce. I'll go with A. The buyer sent a seller an offer to buy 50 tons of cotton for a specified quantity. Oh, sorry, of a specified quality. The offer contained no terms except those specifying the amount and quality of the cotton. The seller then sent an acknowledgement by fax. The acknowledgement repeated the terms of the buyer's offer and stated the shipment would occur within 5 days. Among 12 printed terms on the acknowledgement was a statement that any dispute about the cotton's quality would be submitted to arbitration. Neither the buyer nor the seller said anything further about arbitration. The seller shipped the cotton and it was accepted by the buyer. A dispute arose between the buyer and the seller as to the quality of the cotton, and the seller asserted the dispute had to be submitted to arbitration. The buyer instead sued the seller in court. In that suit, which of the following arguments best supports the seller's position that the buyer must submit the dispute to arbitration? A. Arbitration is a more efficient method of resolving disputes than resolving them in court. B. The provision for arbitration did not contradict any term in the buyer's contract. C. The provision for arbitration did not materially alter the party's contract. D. The seller's acknowledgement containing a provision for arbitration constituted a counteroffer that was accepted by the buyer when it accepted delivery of the cotton. So D would be the case if there was a thing that if it did materially alter, if arbitration did materially alter the freaking contract, then D would be the right answer. A is not the right answer. Um, in a, what was it? All right. I think we'll do this last question here and then probably call it good for tonight. We've gone for quite a while. So let's see here. We'll get to 60. We'll get to 60. A car manufacturer produced a car that was sold nationwide. Problems with the car's brakes allegedly caused several accidents and injuries. Two individual buyers of the car each filed a class action. Car manufacturer produced a car nationwide. Problems with the car's brakes caused accidents. Two individual buyers of the car each filed a class action in different states against the manufacturer, asserting the same product's liability claims on behalf of all buyers nationwide. One class action was filed in federal court, the other was in state court. The parties in the federal action reached a court-approved settlement. The court entered judgment dismissing the action with prejudice. The parties in the federal action reached a court-approved settlement in the court. Okay. The manufacturer's attorney has moved to dismiss the state court action on the basis of res judicata, claim preclusion. So the state court looked to federal or state law to decide the effect of the judgment. A, federal law because the judgment was issued in federal court. B, federal law because the judgment resulted in nationwide action governed by the federal class action rule. C, state law because the judgment is being asserted in state court. D, state law because no general federal common law preclusion, because there is no general federal common law and preclusion is a common law doctrine. Well, there is claim preclusion, res judicata, and there is issue preclusion, which is estoppel, collateral estoppel, that both applies. I mean, the question is what the see. I'm not sure about this one. I'm not sure about the federal class action thing, but so basically, should the state court look to federal or state law to decide whether the state or whether the federal settlement is res judicata in state action? See, I don't think so. So two individual buyers filed, okay, against the manufacturer, yada, yada. Parties in a federal action reached a settlement, and the court entered a judgment diminishing the action in a federal court with prejudice, right? So it's filed in the same thing. So the manufacturer's attorney moved to dismiss the state court action on the basis of res judicata claim preclusion. So the state court looked at federal or state law to decide the effect of the judgment. I think it should look to state law because there's no federal common law and preclusion, but that's not true. Preclusion is not a common law doctrine. Claim preclusion is been adopted by federal courts. I'm looking at state. It's gonna be state law because it was based. I mean, I'm not sure if this is right or not, but it's gotta be state law, I would think. A woman owned a house and a lot abutting a public street. 6 months ago, the city validly revisited its zoning ordinances and placed the woman's lot and the surrounding lots abutting the public street from the north. Okay. Revised its zoning ordinances and placed the woman's lot and the surrounding lots abutting the public street from the north in a zone limited to residential use. The lots abutting the public street on the south side were zoned for both residential and light business use. The woman asked the city's zoning appeals board to approve her proposal to operate a court reporting service from her house. This type of use would be permitted on the south side of the public street, and in fact, one such business has existed there for several years. The board approved the woman's proposal. Why? A variance was granted. The doctrine of amortization applied. The doctrine of changes in circumstance applied. The woman's use of her house was in non-conforming use. I think it's amortization, but I'll double check. I think it's amortization. Because the business was oh, I guess amortization is not right. Huh. So it's non-conforming use, right? But so it's probably a variance then. Yeah, it's gonna be a variance. All right, a common law jurisdiction defines first-degree murder as any murder that is one committed by means of poison or premeditated. All other murders, second-degree, and manslaughter is defined in common law. An employee was angry with her boss for denying her a raise. Intending to cause her boss discomfort, the employee secretly dropped into his coffee 3 over-the-counter laxative pills. The boss drank the coffee containing the pills. Although the pills would not have been dangerous to an ordinary person because the boss was already taking other medication, he suffered a seizure and died. If the employee is charged with first-degree murder, should she be convicted? Yes, because she used poison. Yes, because she acted with premeditation. Yes, both because she poisoned and because she acted with premeditation. No. I mean, it's obviously C. All right. Well, I think we're gonna hit pause on this thing. We'll pick it up in the morning or maybe later today, or I guess later today. Pause. If you choose to pause the test, your progress will be saved. And next time you log in on the web or mobile device, we'll start off where you left off. Guess what pausing means? Cool. Oh, hey, we got 61% correct so far. Well, that's not fucking great, is it? We started off real good. Look at that. 1, 2, 3, 4, 4 right off the bat, and then fucked it up, fucked it up, fucked it up, fucked it up. I didn't know we could have paused it and gone over answers. I should have done that. Sorry, y'all. I didn't know that we could go over answers by pausing it and starting up. So here's what we'll do next time. Next time we'll go over the answers we already did, and we'll start taking the rest of the test and just go. We'll do like 10 or 15 at a time, and then go back and look the freaking answers, and 10 or 15 times go back and look the answers. So this is the first one I've done, so it's good to know how that works out. So well, that's good. That's going. Criminal procedure is going shitty. Evidence is going okay. Torts is okay. Real property is going okay. Contracts is our strong suit. Civ Pro is okay. Well, we'll see if we make a comeback. All right, guys, we're going to go ahead and end the stream. Thank you all. We'll stream on later today. Y'all have a blessed one and take good care. Cheers.